Welcome to Professor's Corner, a monthly webinar sponsored by the ABA section of Real Property, Trust and Estate Law, Legal Education, and Uniform Laws Group. Moderating the program today is Professor Jim Durham of the University of Dayton School of Law. Jim, you may proceed.
Thank you, and good day. I'm Jim Durham, and I'm happy to welcome you today to the December Professor's Corner webinar, sponsored by the Real Property, Trust and Estate Law sections, Legal Education, and Uniform Laws Group. On the second Wednesday of each month, our group hosts a webinar that features a panel of professors, each of whom talk about one or more recent cases of interest to the practicing bar, as well as to other academics. ABA RPTE members enjoy many free dial-in programs like Professor's Corner. If you aren't a member of the RPTE section, we encourage you to join us and take advantage of great membership benefits like this webinar. Before we get started with this month's webinar, please note that next month's webinar will be on Wednesday, January 8th at 12:30 Eastern. The theme of the January webinar will be Recent Developments in Fair Housing, Mount Holly, and Disparate Impact. Our speakers will be three of the nation's leading fair housing scholars, Professors Robert Schwem, Florence Roisman, and Rigel Oliveri. Please mark your calendar for that program. This month's program is Ownership, Transfer, and Enforcement of Securitized Mortgage Loans. We are fortunate to be joined by two leading experts in the field. Let me introduce each of them briefly, and then we'll get started. Our first panelist is Neil Cohen, the Jeffrey D. Forcelli Professor of Law at Brooklyn Law School. Neil's distinguished teaching career has taken him from the Seton Hall University School of Law to Brooklyn Law School, and he has twice been a visiting professor at Columbia Law School. Neil teaches courses in domestic and international commercial law, contracts, and conflict of laws. He has published numerous law review articles in the field of commercial law, as well as in the fields of bankruptcy, medical malpractice, probability and statistics, and baseball in the law. And he is co-author of a leading contracts casebook. Neil is the research director of the Permanent Editorial Board for the Uniform Commercial Code, and he was the reporter for both the revised Article 1 of the Uniform Commercial Code and for the American Law Institute's Restatement of the Law of Suretyship and Guarantee. He is a fellow of the American College of Commercial Finance Lawyers. Our second panelist is Dale Whitman, who is this year a visiting professor of law at the Florida A&M University College of Law. He is the James Campbell Emeritus Professor of Law at the University of Missouri-Columbia. Dale has had and continues to have as a visitor a distinguished teaching career during which he has served as Missouri's dean and as president of the Association of American Law Schools. Dale's principal fields of interest are property and real estate finance, and he is viewed as one of the country's foremost scholars in these areas. He is the author of numerous articles and is a co-author of 5 books, including the pre-eminent treatise on real estate finance law. He was a co-reporter for the Restatement Third of Property Mortgages and reporter for the Uniform Power of Sale Foreclosure Act. He is a member of the Order of the Coif, the American Law Institute, the American College of Mortgage Attorneys, and the American College of Real Estate Lawyers, and he also is a fellow of the American Bar Foundation. We'll start with Professor Cohen. Neil will discuss the application of rules in the Uniform Commercial Code to the determination of rights under mortgage notes, and then Dale will take us one step deeper into the legal morass surrounding mortgage foreclosures by examining the applicability of violations of pooling and servicing agreements and the Internal Revenue Service's REMIC rules in the determination of rights of the parties. Neil?
Well, hello, everybody, and welcome. As Jim mentioned, I'm going to be talking about the applicability of the Uniform Commercial Code to some of these basic issues, and then Dale will take us quite a bit more, take us on a more sophisticated journey into some of the aspects of this. But let's start relatively simply. And quite honestly, mortgages standing alone really are quite simple. The basic idea is a twofold deal, with each part typically reduced to a separate, somewhat standardized legal instrument. And the basic deal, again, is quite simple. In exchange for money or other value now, the obligor makes a promise to pay money later, and this is typically reduced to something known as a promissory note. And accompanying that promise, because the promise alone may not be enough to convince the lender to part with money, is an agreement that certain property, certain real property, is collateral for the obligation to repay. The security interest is typically called a mortgage or a deed of trust, depending on the jurisdiction involved. And so that's a relatively simple structure. And in the good old days of legal simplicity, that's all you really needed to know. And of course, the good old days were the days of lend and hold. They were good old days in terms of at least the simplicity of the structure with which lawyers had to deal. Now that those good old days are over, and now we have rather sophisticated mortgage markets that create rather complicated arrangements, and that's really what we're going to be talking about today. Now, arguably, these mortgage markets make mortgage finance more efficient, but they certainly make it and make ascertainment of the rights under mortgages legally more complex. And that is what we're going to be talking about, because now what happens typically is that the original lending is followed by a series of transfers from the original lender to a whole series of parties, and that makes the transaction and the rights much more complex. Not only are the rights transferred repeatedly in the typical mortgage markets, they're also transferred by a variety of mechanisms. Some transfers are accomplished solely by contract. Others are through contract plus delivery of an instrument. Sometimes endorsement is involved, sometimes it isn't. And all of these differences can create differences in legal rights. And the other thing we've all learned through difficult experience is that people who effectuate these transfers sometimes aren't people who pay a whole lot of attention to detail. So we get lots of variations and lots of questions about who has what right that are generated by people who weren't very careful. And so that's the situation that we find ourselves in. And again, determining the legal rights is quite complex. And what comes as a surprise to quite a few people is that many of the answers as to who has what rights are determined not so much by mortgage law or real estate law, but rather by commercial law. And that's what we're going to be talking about next. What rights, what matters are governed by commercial law. And basically, three questions that are quite important in this area are determined by the commercial law of the jurisdiction involved. And the questions are similar, but they're not identical, and they often have different answers, and the answers are reached through somewhat different statutory routes. The first two relate to the promissory note. Who can enforce the promissory note, and who owns the promissory note? You might think that the answer to those two is always the same, but it isn't, and we'll talk a little bit later about why those two may be different. The third one, who owns the mortgage? Again, you might think that all three have the same answer, but they don't always have the same answer. And when they differ, things can get interesting, particularly when the first one differs from the third one, or the second one arguably differs from the third one. But again, we'll talk about that in a moment. But the key here is that these three questions are answered primarily by commercial law. So what commercial law does one need to know in order to determine rights in this area? Well, let's focus on the first question: who can enforce the promissory note? Well, what law one needs to know, first of all, depends on whether the promissory note qualifies as a negotiable instrument. That's a term of art under Article 3 of the Uniform Commercial Code. In particular, it's Section 3104, and you may recall from law school or from more recent experience that there are a set of criteria, all of which must be satisfied in order for something to qualify as a negotiable instrument. In the context of a promise to pay money, you need an unconditional promise to pay a fixed amount of money. It's got to be payable to bearer or order. It's got to be payable on demand or at a definite time, and there has to be no other undertaking embodied in this signed piece of paper. If the promissory note is negotiable, then The issues with respect to enforcement of that note are governed by Article 3 of the Uniform Commercial Code. On the other hand, if it's not a negotiable instrument, Article 3 does not govern, and the piece of paper is probably just a contract, and as a result, contract law largely determines who may enforce the promise. In a number of jurisdictions, however, because the promise is embodied in this thing that looks like it's a separate legal instrument, even though it may not qualify as a negotiable instrument, there are some jurisdictions that treat the piece of paper itself as embodying the right and apply some rules similar to many of the rules in negotiable instruments. But in any event, Article 3 doesn't govern. Now, luckily for us, most of the time we'll see that Article 3 does govern, but that's the first set of rules. For determining who may enforce the promissory note, we're primarily in Article 3 of the Uniform Commercial Code. In terms of the other questions, we're over in Article 9, the other end of the code. Who owns the promissory note? And again, once it's been sold or used as collateral, Article 9 gives us the answer, and that's the case whether or not the note is negotiable. So we'll have need to figure out whether the note is negotiable in order to determine whether Article 3 applies, but we won't need to know whether the note is negotiable in order to know whether Article 9 applies. And then a similar but not quite identical problem is who owns the mortgage. And once again, Article 9 determines the answer, and as we'll see in a few minutes, what Article 9 has done in this area is to codify the common law rules that draw the connection between ownership of the note and ownership of the mortgage. Whenever I talk to attorneys about this, the first question I get, and it's quite a good question, is why is Article 9 even relevant? Everybody knows what Article 9 is about. Article 9 is a statute that governs transactions in which personal property is collateral for an obligation. This is a real property transaction, and if it's a real property transaction, what does Article 9 have to do with it? Well, it is a real property transaction, but we've got two ties to Article 9. One is the promissory note itself is personal property, but the other, and even more important, is that Article 9 does govern transactions where personal property is collateral, but that's not all it governs. If you look at Section 9109A3 of the UCC, we see that Article 9 not only governs transactions where personal property is collateral, but it also governs sales of four types of payment rights: accounts, chattel paper, payment intangibles, and most important for our purposes now, promissory notes. So even if there isn't collateral, a security interest in the note anywhere in sight, the very fact that a promissory note is sold means that Article 9 is relevant. So both Article 3 and Article 9 do play a role here, and as those of you who know the UCC well know, that whenever any article of the UCC is involved, general principles that are in Article 1 of the Uniform Commercial Code also apply. So let's go back to the promissory note for a moment and see what questions need to be answered with respect to the promissory note itself, even before we return to the mortgage. The first question is who's entitled to enforce the promissory note, and the second one is who owns the promissory note. And as the slide you see indicates, it's different parts of the Uniform Commercial Code that determine the answer. Article 3 tells us who's entitled to enforce the note, who's entitled to go after the obligor, the maker on the note. And it's Article 9, on the other hand, that tells us when there's been a purported sale of the note or other transfer of the note, who it is who actually owns the note. And the last question you see on the slide is a quite important question. Is, why would the answers to these two questions ever be different? Shouldn't the person who is entitled to enforce be the owner and vice versa? And the answer goes back really to why we would ask these questions. Enforcement is about the rights and duties of the obligor. You enforce a note against the obligor, the maker of it, of the note, or perhaps an endorser of it. And in a world where notes move around, obligors need simple rules that are verifiable by the obligors to figure out to whom they owe their payment rights, to whom they owe their payments in order to be discharged on their obligations. And so we have a set of rules that are really designed to be protective of obligors and easily applicable by obligors that determine who may enforce the right against the obligor, against the maker of the note. On the other hand, ownership is not an issue really about the obligor. Ownership is an issue of rights as between competing owners. Did the original owner, in fact, effectively transfer ownership to the person who purports to be the successor? And rights between competing owners need not necessarily be resolved by the same legal principles that determine to whom the obligor is answerable. And in fact, as we'll see, Article 3 and Article 9 take somewhat different paths here, so we can have a situation where the owner and the person entitled to enforce are in fact different parties. So let's move to the first question and walk through that one. Who is it that can enforce a promissory note? In the old days, where lenders just held onto the paper, it was pretty obvious. It was the lender who got to enforce. But now that the note may have been transferred many times by contract, by delivery, by endorsement, we need to know to whom the obligor is answerable. And as I mentioned earlier, the answer to that depends significantly on whether the note is negotiable under those criteria in UCC Article 3. In the context of residential real estate notes, the assumption for many years had been that, of course, they were negotiable, that the people who drafted the notes, which are usually in somewhat standardized form, knew enough to make them negotiable. They had magic words like "to the order of" in them, and the world went along treating them as a negotiable instrument. But in the last several years, some scholars have argued that these standard form notes, the Fannie and Freddie notes, aren't negotiable because of some of the clauses in them that would violate the no other promises and undertakings requirement of negotiable instruments. Whether or not the scholars are correct, the courts have overwhelmingly disagreed. And I think it may be 12 cases now that have held that those standard form notes are indeed negotiable instruments. So I think from this point forward, we should assume in our analysis that we do have a negotiable instrument embodying the obligation to pay money. Commercial real estate loans, on the other hand, are often done through non-negotiable instruments, and so again, it would be primarily contract law that would govern this first issue. But in most real estate transactions, most residential real estate transactions will have something that the courts are likely to find to be a negotiable instrument, and as a result, Article 3 will govern. Now, one cautionary note here, Article 3 is Article 3 of the Uniform Commercial Code, but it's not completely uniform here. The UCC is now over 50 years old, and one of our states has the original version of Article 3 of the Uniform Commercial Code. That's New York. New York seems to be leading from behind here with the antique version of Article 3. Every other state has at least enacted the so-called 1990 text of Article 3 of the Uniform Commercial Code. And these slides are based on the 1990 and forward version, so section numbers and the like will be slightly different in New York. In addition, about 10 states have adopted a series of amendments to the 1990 text, and they have what's known as the 2002 text of UCC Article 3, with one exception that I'll note in a few moments. There's not much difference for our purposes between the 1990 and the 2002. So who is it that can enforce a promissory note under Article 3? The answer is PEET gets to enforce it. PEET is an acronym for person entitled to enforce the note. And we know that's the answer because Article 3 tells us. Section 3.4.12 of the UCC tells us that the obligation of a maker of a note is owed to the person entitled to enforce it, and Section 3.6.02 tells us that if the obligor pays the person entitled to enforce, the obligor is discharged. So Pete is the key person here, and Pete is the person to whom the maker is accountable, and that's the case whether or not the person who's entitled to enforce also happens to be the owner of the note. So how do we determine who this person is, who Pete is, the person who's entitled to enforce the note? The answer is found in Section 3.301 of the UCC, and that section gives us three ways in which a person can qualify as a person entitled to enforce an instrument. And you see them all on the screen in front of you. You can be a person entitled to enforce if you're the holder of the note. You could be a person entitled to enforce if you're a non-holder of the note in possession of it and you have the rights of a holder. That's a real mouthful. And finally, in certain contexts where a note has been lost or destroyed, you can qualify as the person entitled to enforce the note. Notice, most importantly, though, that those first two possibilities require the person who would like to be a Pete to actually be in possession of the note, and that's a very important point. So let's look at the first possibility, the holder. How do you determine whether someone's a holder? Well, like everything else in the UCC, we've got to look to the definitions. And this term is defined in Article 1. It's defined, as you see, in 1201B21. That doesn't sound detailed enough. I should tell you I left off a capital A at the end. It's 1201B21, capital A. And there are three requirements. You have to have possession of the note to be the holder. And it has to be either a bearer instrument, pay to the order of bearer or cash or something like that, or it has to be possessed by the person to whom it's payable. Actually, I'm sorry, just those two elements. But the difficulty here is most mortgage notes, like most notes, say pay to the order of somebody. They don't say pay to the order of bearer. And the somebody that they typically state is the original lender. And so you have a note that says pay to the order of lender, and now somebody else other than the lender wants to be the person entitled to enforce. Well, can that person ever be a holder? And the answer is yes, because even though to be a holder you have to be in possession of a note that is either a bearer instrument or is payable to you, to whom a note is payable is changed by endorsements. And I think we all know this from a sort of an instinctive level, having dealt with notes and checks. When you endorse an instrument, what you've done is you've changed to whom it's payable. If you do what's called a blank endorsement, just sign your name, it becomes payable to bearer. Anyone in possession of it can be the holder. If you have a special endorsement, if you write pay to Neil Cohen on the back and then sign your name, then it's as though the front of the instrument was amended and the pay to the order of line now has that new person's name, and that new person in possession can be the holder. So it is indeed possible to be the holder of an instrument that states on the front that's payable to somebody else. So again, being a holder of a promissory note is one way to be the person entitled to enforce it. But it's not the only way. The second way to become the holder under Section 3.301 is that mouthful again, to be a non-holder in possession of the note who has the rights of the holder. Again, the key here is possession, but for this section even to be relevant, it must be the case that possession doesn't make you a holder, because if possession made you a holder, you'd qualify on that earlier criterion. So maybe you're in possession of an instrument that's payable to the order of somebody else, and that somebody else didn't endorse it. Well, in that case, again, you can qualify as a person entitled to enforce if not only are you in possession of the note, but you have to have the rights of a holder. Well, how would you ever get the rights of a holder if you're not a holder? And there's basically two ways here. One is by operation of law. Perhaps you're subrogated to the rights of a holder, or the holder has died, and by operation of law, you're the person who inherits the rights of the holder. More commonly, though, you can become you can get the rights of a holder by a concept known as transfer. And transfer is actually a defined term of art in Article 3. Transfer requires delivery of the note to you, and not only delivery, but delivery for the purpose of giving you the right to enforce. So if I sell you a promissory note, and I say I'm selling it to you, and I hand it to you, and I say here it is, it's all yours, but I forget to endorse it. Well, I have delivered it to you for the purpose of giving you my rights to enforce, and what Section 3203 tells us then, in that case, my rights to enforce, including my rights as a holder, have been transferred to you. So you are now a non-holder in possession of the instrument who has the rights of a holder. So those are the two ways someone can qualify as a person entitled to enforce. And this second way is important because a number of people think that only someone who qualifies as a holder can enforce a note, someone who is in possession of an instrument endorsed to him or to her, and that's not the case. This second element of PET status can enable enforcement by a non-holder, but it requires some proof because having possession of the instrument isn't enough. You have to prove that you got it by transfer. Well, what if nobody's in possession of the note, or at least nobody we know, because something happened to the note? And that's the third way someone can qualify as a person entitled to enforce a note. It's through the so-called lost note rules or lost instrument rules, and they're in Section 3309 of the Uniform Commercial Code. You can enforce a note. You can be a person entitled to enforce, even if you don't have it, if you were the person who had it when loss occurred, and you can't get the note because nobody knows where it is, or it was destroyed, or it's in the possession of someone who's beyond the service of process. One often talks in this area about lost note affidavits. The statute actually never mentions that, but that's a very common way to assert and demonstrate that you qualify for PET status under this sort of so-called lost note scenario. One issue that's arisen in this area is, can a transferee of a lost note, not the person who lost it, but someone who acquired rights from the loser, also qualify as a PET? Most commentators thought the answer was yes, but a few early cases said no. The most prominent one in the District of Columbia is known as the Dennis Joslin case, and one or two other state courts followed that. And as a result, in the 2002 amendments, which have now been enacted by 10 states, the statute very explicitly says that a transferee of a lost note can also qualify as a person entitled to enforce the note. If you're in a 1990 state, there are only a few states that have addressed it, and they have split. Most states haven't addressed the issue at all. If you're in a 2002 state, the answer is definitely yes. How about defenses to the payment obligation? Well, most of the time there aren't defenses because, in fact, the borrower got the money. Sometimes, however, predatory lending situations and the like, defenses might be available, and then the question is, can they be raised against the person entitled to enforce? And as you can see from the slide that's on the screen now, the answer is it depends. It depends on whether the person entitled to enforce qualifies as a holder in due course. To be a holder in due course, obviously you have to be a holder, and you have to satisfy the other criteria in Section 3302. And a holder in due course takes free of all defenses except the so-called real defenses, and those real defenses are listed in Section 3305A1, and they hardly ever arise. So if you have a defense to raise, you need to hope that the person against whom you want to raise it does not qualify as a holder in due course. Okay, so that's step one, and that's actually the hardest step. The other steps are much easier. Now that we know to whom the obligation is owed, who may enforce the obligation, how about moving from owing to owning? Who owns the promissory note? Well, it starts off being owned by the payee, once the payee sells it, or at least purports to sell it, what does it take to actually effectively transfer ownership? And again, this is answered by Article 9, because Article 9 governs sales of promissory notes. Now, if you jump to the operational sections of Article 9, you won't see anything in them about sales of promissory notes or sales of just about anything else. That's because Article 9, rather than talking about sales in every section, uses some terminological conventions, some terminological arbitrariness to squeeze sales in. And so if you look at the definitional parts of Article 9, you'll see that the definition of secured party includes the buyer, the definition of debtor includes the seller, et cetera. You can see them all on the screen. And as a result, when you look at the operational sections of Article 9, if you substitute these concepts for the defined term, you'll see that those terms actually do operate there. So now, who owns the promissory note? Well, the question is whether we have an effective sale. 3 elements. They're in Section 9203B of the UCC. Value has to have been given. The seller had to have rights in the note. That's the old Nemo dot principle of property law. And finally, the third element. The third element can be settled 2 ways. Can be satisfied 2 ways, either by the buyer taking possession or by an authenticated, and this means signed or its electronic equivalent, an authenticated agreement. So you can become the owner of a promissory note by satisfying those 3 elements without ever becoming the person entitled to enforce if you didn't get possession of it. And slide 21 that you see in front of you now gives some examples of that. To whom is the obligation owed? That's the PET. Who owns it? Well, the buyer owns it if the 3 elements of 9203B have been satisfied. And again, that doesn't require possession if there's a signed agreement. The third of the 3 questions, who owns the mortgage? And the answer is found in Section 9203G, but it's also the answer we see in the common law of most but not every state. 9203G says it in legal gibberish. If you translate it into English, it boils down to the transfer of ownership of a promissory note also transfers ownership of the mortgage. Again, it's similar to the common law of most states, but 9203G has been enacted by statute in every state. And so every state has this rule as a matter of statute. So the UCC has answered 3 really important questions here. Who's the person entitled to enforce? Who owns the note? Who owns the mortgage? But it hasn't answered the $64,000 question, or perhaps, given the size of the market in this area, I should say the $64 trillion question. And that is, who's entitled to enforce the mortgage? Is it Pete? Or is it the owner of the note and the mortgage? And the answer, at least as far as the Uniform Commercial Code is concerned, is we're not going to tell you. This is the one question, and it's the key question, that the UCC does not answer. This is the one that comes from real estate law. And for the most part, states have held that when those 2 are different, you look to the PET. The person who's entitled to enforce the note is the person who's entitled to enforce the mortgage. But since that's not stated in a statute in most places, it's an area of some concern and some difference of opinion, but that is certainly the primary answer here. In determining, again, the rights of people on mortgages that have been bought and sold and promissory notes that have been bought and sold, the big message here is that, quite surprisingly to most people, most of the answers come from commercial law rather than real estate law, but that last piece, assembling it all, does indeed come from real estate law. Now I'm going to turn the microphone over to Dale, who's going to delve even more deeply into the operational details of what happens when mortgages are transferred and promissory notes are transferred, particularly in the securitized mortgage market, and he's going to focus on claims that can be raised under pooling and servicing agreements and under tax rules with respect to REMIC. So Dale, it's all yours.
Okay, thank you, Jim. We're mainly going to talk about what we call private label securitizations here. private label securitization was a major source of residential mortgage funds until the collapse of the market in mid-2007. By the end of 2007, private label securitizations had essentially disappeared and are only now just gradually beginning to come back. But there are a huge number of loans that were made by private label securitizers. They're still outstanding and are now in the process of being foreclosed. So it's an awfully important area. Fannie and Freddie also did a lot of securitizations, but they were far, far more careful in doing it right, in dotting the I's and crossing the T's than the private label securitizers were. So most of these issues just don't come up with Fannie and Freddie's securitizations, but they do with the private label ones. There are two related issues that we're going to talk about. One of them is if this wasn't done correctly, if the rules weren't followed, can a borrower use those violations as a defense to foreclosure? And the second one is, could the IRS use the failures or violations as a basis for revoking the pass-through tax status of the securitization trusts? And that, of course, could be financially devastating to the bondholders who bought the securities. So we're going to begin by looking at what's in a pooling and servicing agreement, or a PSA, as it's usually called. It's a critical document in private label securitizations. It's sort of the constitution or the charter of the securitization. It's long, it's boring, and I don't know if anyone has ever actually sat down and read one from beginning to end, but it essentially gives us the structure of the securitization. Here's a little picture that in greatly simplified form shows how the notes and mortgages were expected to flow or move through a securitization. We start with the mortgage originator. This is the party that's made the loan to the borrower. It may go through multiple parties before getting to a sponsor or aggregator, and the sponsor is really the party that's putting the securitization together. Now, before transferring the notes and mortgages to the trustee of the securitization, they always ran the notes and mortgages through a depositor. That's a special purpose entity that's intended to be bankruptcy remote and is intended to protect against the possibility that a bankruptcy of either of the previous parties or any of the previous parties might result in the trustee in bankruptcy trying to call back the notes and mortgages. So you run it through the special purpose depositor and to the trustee. The trustee is typically a bank, usually a New York bank, but not always so. The bank or trustee will almost always have a separate custodian. It might be its own custodian, but the custodian is somebody who physically stores the documents and keeps physical control of them. And then, of course, there will be a servicer. I've just indicated a master servicer here, but in reality, there may be multiple servicers. There may be sub-servicers or special servicers. The basic purpose of a servicer is to collect the payments and keep records of what's happening with the loan and to foreclose it if it becomes necessary. Now, the pooling and servicing agreement is the document that the depositor, the trustee, and the master servicer all sign, and that's intended to sort of set out their rights and obligations. In addition, the pooling and servicing agreement normally will have as an appendix an actual list of the loans that are being transferred into the securitization. I'm not saying that that's always present, because sometimes it seems at least that nobody ever bothered to get around to attaching that, but there ought to be a listing of the loans themselves. Now, what does the pooling and servicing agreement say about delivery of documents from the depositor to the securitization trust? Typically, it'll say, first and most important, that the original note has to be delivered with all of the necessary endorsements. As Neil mentioned, either an endorsement in blank, which was very common, or it could be a special endorsement. Then there'd be the mortgage showing it having been recorded. A chain of mortgage assignments is often required, any assumption, modification, or substitution agreements, and the original title policy. Now, there's a little variation from one PSA to another, but these are commonly the documents that are supposed to be delivered. The time of delivery, well, it could be on or before the closing date. The closing date is essentially the date that the securitization commences. But there is a window period for delivery after the closing date, and if that's done, at least in the pooling and servicing agreements that I've looked at, there's a provision that says the contents that are not delivered on or before the closing date are held in trust by the seller, that's the depositor, for the benefit of the purchaser being the securitization trust. So in a way, they have a beneficial interest in them even if they haven't been delivered, according to this language. Now, the pooling and servicing agreements invariably say that all of the parties are going to comply with what we call the REMIC Rules and not cause any violation of them that would endanger the tax status of the securitization as a REMIC. A REMIC is a real estate mortgage investment conduit. It's a special status allowed by Congress under the Internal Revenue Code. It's found in Section 860 of the Code. And it allows the trust to basically be a pass-through tax entity and not to owe taxes on its own, so that the interest and other payments that are collected on the loans become income not to the trust itself, but only to the bondholders who hold certificates from the trust. In order to be a qualified mortgage under the REMIC rules, it's got to be one that's purchased by the REMIC, as you see at the bottom of the slide there, within the 3-month period beginning on the startup day, and that has to be pursuant to a fixed price contract that was in effect on the startup date. However, in real life, in many cases, the notes and the other documents that we listed on the previous slide were not delivered during that 3-month period, and in fact may not have been delivered for many months or even years afterward, perhaps only when the trustee or its servicer wanted to foreclose and discovered that it didn't have the documents in the hands of its custodian. And so the depositor and arguably the trustee as well were in violation of the PSA if they didn't deliver the documents within that 3-month window. So what are the consequences of that? Well, there's to pick a sort of paradigm case, and there aren't many of these. The Arabobo case decided earlier this year in the trial court in New York, and this is only a trial court case, decided on April 29th of this year. The court held that the trustee had exceeded its authority and violated the terms of the trust, and under New York trust law, there's a line in the statute that says every act of the trustee in contravention of the trust is void. And so the argument is, and Arabobo accepted this argument, that if New York law governs, the note transfer itself is void, and in other words, never really happened. Now, other states don't typically have language like this in their trust statutes and probably would not at all agree that the act of a trustee outside the competence of the trust document is void. But New York is kind of unique in having that language, and so it raises an issue about whether the transfer, if it took place outside the 3-month window, really took place at all. In the Arabobo case, there was actually one additional problem, which is kind of bizarre. The sponsor there, with regard to the particular loan in question in the case, delivered it directly to the trustee instead of running it through the depositor, the special purpose entity that's supposed to ensure bankruptcy remoteness. And that also, of course, was a violation of the PSA, and another reason that arguably the transfer was void. Well, the question then becomes, are acts of a trustee outside of its authority in New York really void? And the answer, I think, is likely no, they're not, but the Arabobo case obviously says that they are. The Vermont Supreme Court considered this a little later this year, on October the 18th, in the Dernier case, and the opinion there, which is a well-thought-out and well-written opinion, says that the New York courts, although they're somewhat conflicted on the matter, and there are cases on both sides of this in New York, generally find, despite that very strong language in the statute, that the actions of the trustee outside the scope of his authority are voidable rather than void. And the Vermont court said unauthorized actions of a trustee are ratifiable by the beneficiary of the trust. And if it's ratifiable, then it's voidable rather than void. Why is that important? Well, it's important because if it's voidable rather than void, the general common law is that a third party cannot attack the action or the transfer, that it's only a matter between the beneficiaries and the trustee, and a borrower, for example, on a loan would not have standing to attack it. So the Dernier court in Vermont said, we hold the plaintiffs don't have standing to challenge the assignments of the note and mortgage based on these violations of the PSA, because those violations would render the assignments voidable instead of void. I put at the bottom of the slide there a couple of additional cases that are well written and well considered that take the same view. The Bassman case in the Illinois Court of Appeals and Calderon, a very well written case in the Federal District Court in Texas earlier this year. Now, there is another case that agrees basically with Arabobo and takes the view that the void language of the New York statute applies literally, and that's Glaske being decided on August the 8th of this year. And the Glaske court gave a kind of an amusing reason for deciding the way it did, at least I find it kind of amusing. They said applying the statute to void the attempted transfer is justified because it protects the beneficiaries of the trust from the adverse tax consequences of the trust losing its REMIC status. Well, if I were a beneficiary of the trust, I might be inclined to say, gee, thanks a lot, but I don't need that kind of help. Because essentially what that decision does is to say, yeah, we're going to protect your REMIC status, but at the same time, we're basically going to say that you don't have the asset. You can't collect on the debt, you can't foreclose the mortgage, and it's a pretty darned high price to pay for preserving your REMIC status. So we're left with the question then, are securitized trusts in danger of losing their REMIC status and thereby becoming taxable entities? And that's a really interesting question. Here's a little more information about the REMIC rules under Internal Revenue Code 860. As I mentioned, they allow the trust to be a pass-through entity and not to be taxable in its own capacity. And they do have this provision that says substantially all the mortgages have to be transferred into the pool within 90 days from the start date. Literally, what the statute says is transferred to the REMIC on the start date or purchased by the REMIC within 3 months after the start date pursuant to a fixed price contract. So the words are transferred and purchased, and those words are potentially of very critical importance. It's not clear whether transfer and purchase refer to PEB status, as Neil was describing it a little earlier, or to ownership, or conceivably it means both. The usual assumption, I think, is that it means ownership. And if it does, then the problem may not be as severe as it seems, because the PSAs almost always, at least every one I've looked at, contains language of present sale and transfer. And I put a little quote at the bottom of the slide there indicating what the language of present transfer looks like. The depositor, concurrently with the execution delivery hereof, does hereby assign, set over, transfer, and otherwise convey to the trustee all of their interest in the mortgage loans that are identified in the schedule. So if there's really a schedule there, if they bothered to attach it, that language would seem to transfer ownership. Now, obviously, that language will not transfer PEB status because only delivery of the notes can do that, as Neil was explaining a few minutes ago. But under Article 9, that language should be sufficient to transfer ownership. As Neil suggested, the seller's got to have rights to transfer, the purchaser's got to pay value, and the seller's got to authenticate a security agreement. And the PSA is, in effect, that security agreement, if it's got the note schedule. So that ought to be sufficient to transfer ownership, even if not PEB status. However, as a couple of scholars at Brooklyn Law School, Brad Borden and David Reese, have pointed out in several articles, the tax code's definition of ownership might not be the same as the Uniform Commercial Code's concept. Brad and David have got a couple of articles that you probably would want to look at if you're interested in this issue. The one that's going to be in the University of Pennsylvania Journal of Business Law is not out yet, but you can see it on the web. If you just type in the title, it'll immediately pop up on Google for you. The one in Probate and Property is a little more general. The one that's going to be in the Pennsylvania Journal gives a very complete, very thorough, detailed discussion of what tax ownership means and how it might differ from state law definitions of ownership. And we don't have time to cover that. It's a fascinating subject. I think their analysis is very well worth reading. I must say that they're a bit more negative on the likelihood that the IRS could attack the REMIC status of these trusts than I am. I think that they probably paint too bleak a picture, but it's certainly worth looking at their approach to it to see how you might estimate the IRS could proceed. Conceivably, the IRS could either rule, and the courts could agree with them, that you do need to transfer PEB status, which again means you've got to transfer a physical delivery of the note within the 90-day window. Or the courts might decide the transfer of ownership is sufficient. You don't have to transfer PEB status as such, but ownership requires having the benefits and burdens of the notes, and necessarily that requires possession of the document. So either way, we might end up with a holding from initially from the IRS and then from the courts that the trusts simply didn't qualify for REMIC status. So to kind of wrap up my discussion, there is a risk that the trusts will be denied REMIC status. It might be a minimal risk if my thought on it is right. If Brad and David's thought on it is right, it might be quite a substantial risk, so opinions vary on that. At this point, the IRS has not taken any steps to decertify the REMIC status of any of the trusts, and one might ask, is this a case of too big to fail? That is, that the implications, if the IRS did take action, would be to make virtually all of the private label REMICs not REMICs anymore, and to be taxable entities with catastrophic tax losses to the bondholders. Whether the IRS acts or not, it is clear that there are a lot of cases in which there was a failure of strict compliance with the PSAs. And there's a difference. I want to close with this. I didn't put it on the slide, but I want to try to emphasize it, if I may. From the IRS's point of view, the only document that's really of any potential importance is the promissory note. The reason is, if the IRS decides that the REMIC has to have, within the 90-day window, the right to enforce the mortgage, the only document you need to do that in most states is the promissory note. Now, there are a few states, about a dozen, where you might also need assignments of the mortgages. But the note, and in a few states, the assignment of the mortgage is everything. You don't need a copy of the mortgage. You don't need the title policy. You don't need any other documents. On the other hand, if you're looking at private foreclosure defense purposes, then the failure to deliver any required document is a breach of the PSA. And if you take the New York statute literally, a breach of the PSA makes the transaction void. Again, I don't think that the taking the New York statute literally will turn out to be a correct interpretation of it, but right now it's very much a live question. So there, I've wound up everything I needed to cover, and we've reached the end of the time for the formal presentation, so it's time for questions. I'll turn it back to Jim.
Thank you, Dale, and thank you, Neil, also. We are now ready to begin taking questions from our live audience. We'll start with our online questions, and we've gotten quite a few. You can submit your questions through the Q&A chat function. For those of you on the telephone, the operator will now give you instructions on how to dial in. Operator?
Thank you. For those on the telephone who would like to ask a question, please press the star key followed by the number 1 on your telephone keypad. If your question has been answered and you would like to withdraw your registration, please press star 1 on your telephone keypad. If you are using a speakerphone, please lift your handset before entering your request. And there are no phone questions at this time, so I'll turn it back to our moderator. Jim?
Thank you, Operator. We're going to go then to the online questions. And Neil, we have a question. State law may have law other than the UCC govern who owns the mortgage. Your response, please.
Well, sure. The provisions in the UCC that I referred to became the law in 2001. And virtually every state had some law before that. And as Dale has exhaustively and with great detail demonstrated in his many works, in the vast majority of states, the rule is the same as the rule in Section 9203G, which is that ownership of the mortgage follows ownership of the note. So the issue really only arises in the small number of states for which that may not have been the case. And in a sense, you may have an internal conflict in those states. Those states all have enacted Section 9203G, which tells us that that transfer of ownership of the note carries with it transfer of ownership of the mortgage. And if their prior law was pre-2001, I think we have a pretty strong argument that 9203G is now the rule, even if a different rule existed before that. On the other hand, real estate law and commercial law tend to be somewhat hermetically sealed fields, and so if you are in one of those states, I think really the thing to do is to watch the judiciary there and see whether they interpret Section 9203G literally or if they simply ignore it.
Thank you, Neil. Then the next question is, if Article 3 doesn't apply, is an endorsement meaningless, or is it evidence of a transfer?
And I think the latter is the case. If Article 3 doesn't apply, then we still have to figure out whether the right to enforce and whether ownership has been effectively transferred. We don't need an endorsement for the Article 9 rule. So for transfer of ownership, just the signed contract and value having been given is enough to transfer ownership. But in terms of transfer of the right to enforce, I think an endorsement is very good evidence. In fact, Article 9 in defining instruments, so it covers not only negotiable instruments but non-negotiable instruments, talks about essentially about pieces of paper that in the ordinary course of business are typically transferred by transfer of possession accompanied by an endorsement. And so that recognition, even in Article 9, suggests that an endorsement of a non-negotiable instrument would be pretty good evidence of what the parties were intending.
I might just add, Jim, that, and I completely agree with what Neil said, it's just very hard to find any modern authority on that point. The reason is that since the adoption of the negotiable instruments law back in the early part of the 20th century, there's been very, very little legal development of the law concerning non-negotiable notes. And so I'm morally certain that an endorsement will act with a non-negotiable note in essentially the same way it does with a negotiable note, but I probably can't find you any case law for the last 100 years on it.
And that's not very reassuring. Next question. Now, how do you distinguish between being a holder and a mere custodian, such as a servicer?
Oh, that's a great question, and this really has to do with the law of agency. Holder is a rigorously defined term in the UCC, but the UCC also says in Section 1103B that the UCC doesn't preempt all the common law that's out there, that it stands on the shoulders of much of the common law, including the law of agency. And so if and since entities, don't have hands, they can't physically hold things. Very often, entities do things through their agents, and a custodian is likely to be one way to think of what a custodian is essentially an agent for purposes of possession. It's someone who's holding possession on behalf of somebody else. And so I think when we plug in standard agency principles into the analysis, we can see the difference.
Let me add just a word about that. The question seems to imply that servicers and custodians are the same, but in practice, in the industry, they're very different. The custodian's function is simply to hang on to the paper, and that's all.
I'm sorry, I was referring to custodians. I apologize.
No, that's fine. But a servicer, on the other hand, is an agent with very active duties, collecting the payments, keeping records of the payments, maintaining the tax and insurance escrow, foreclosing if instructed to do so by the owner. So the servicer has lots and lots of additional duties. Many times when the owner of the note is getting ready to foreclose the mortgage, they will transfer the note to the servicer, so the servicer becomes the holder just because it's more convenient to be the holder when you go into court to foreclose, rather than saying you're the agent of the holder. Say, I am the holder. I've got the note here. And Fannie and Freddie commonly will do that, for example, when they're ready to foreclose.
Thank you, both Neil and Dale. Next question. To prove the transferor intended to transfer right to enforce, you don't necessarily need proof that this right was sold, correct? And the questioner goes on, couldn't the transferor give the note to transferee for any number of reasons?
And the answer is yes. In the examples I gave, I was focusing on sale, but in fact the statute is quite clear and consistent with the questioner, which is that second element of PEB status is possession, accompanied by having the right to enforce, and you get that through transfer, and it's exactly as suggested here. It's for the transfer of possession with intent to give the transferee the right to enforce. It could happen if the transferee is a secured party, and as part of the deal, the secured party is going to do the enforcing. The owner who transferred possession still owns it, but the secured party will do the enforcing. It may be as part of a servicing arrangement, where the owner remains the owner but gives possession to the servicer and wants the servicer to do the enforcing. So there are, in fact, a number of other contexts in which peach status could arise.
Thank you, Neil. And that is all the time we have for today. Just to respond to the last question that was just posted, will the seminar be saved in a library at ABA to retrieve and listen another time? And the answer is yes. That will be on the web page of the Real Property Trust and Estate Law section and under the Legal Education and Uniform Laws group, and it will be available, as are all of the Professor's Corners. Thank you again to our faculty for this program, Neil Cohen and Dale Whitman, for sharing their time and expertise with us. On behalf of the ABA section of Real Property Trust and Estate Law, I'm Jim Durham, thanking you all for joining us. Please join us next month on January 8th for a program on fair housing, Mount Holly, and disparate impact with Professors Robert Schwem, Florence Roisman, and Rigel Oliveri. I will now turn you over to our operator for some additional information. Operator?
Thank you. On behalf of the American Bar Association and the section of Real Property Trust and Estate Law, Legal Education and Uniform Laws Group, thank you for participating in this program. To learn more about the section of Real Property Trust and Estate Law, visit the section's website at http://www.americanbar.org/RPTE. Thank you and have a good day.